Good morning, everybody, and welcome to the District of Columbia Court of Appeals. I know we have some visitors here, so welcome to you. Also, never a dull moment. Right at the moment we were coming in, there's a fire alarm. I am assured that everything's fine in the building and it was a false alarm or something, but thank you for dealing with that and adapting. We have 3 cases on this morning's calendar. The first one is 23 CF 432, Stephen Robin versus United States.
Good morning, and may it please the court. Sarah McDonald on behalf of appellant Stephen Robin. I'd like to reserve 2 minutes for rebuttal. During the crucial stage of jury deliberations, a U.S. Marshal took it upon himself to answer the jury's question whether the magazine could be loaded in the evidentiary firearm. The decision about how the jury could assess the key physical evidence needed to come from the trial judge with the knowledge and input of the parties, and the failure to follow these procedures violated Mr. Robin's constitutional rights. I want to highlight 3 features of what happened in the jury room that made the complete absence of the judge and the parties a constitutional problem. First, there was more than one possible way to respond to the jury's question. Second, the answer had not been predetermined. And finally, the marshal had the final say on the jury's question. These features meant that a judge had to answer the question and that Mr. Robin's presence would have contributed to the fairness of the proceeding. Given the facts and the arguments in this case, the question whether reversal is required, I think all turns on whether the marshal's ex parte communication was the exercise of a ministerial function. And because there was more than one possible response to the jury's question, that just cannot be the case here.
What do you think the other potential responses were?
Sure. So the other potential responses do not have to be, as I think the government suggests, no, it's impermissible to load the magazine in the firearm. This could have played out in a number of possible ways. The judge could have determined that a cautionary instruction was in order if the state in which the firearm was presented in the courtroom, in which the jury is told the firearm is cleared, is going to change. The judge could have decided if that change is going to happen, that needs to happen in open court. The parties could have made arguments about how to proceed with it.
But why would the judge think that? I mean, anytime, so the instructions on exhibits, all the trial exhibits are going back with the jury, right? And if this case were about, a lockbox and a key, the jury could take that key and try it out in the lockbox, right? They wouldn't have to ask anybody for permission. The concern here is it's a gun, so it poses some safety concerns, and they should be permitted to do whatever is within the realm of safety, something that is particularly within the marshal's wheelhouse. So he says you can't load it, which makes sense, but not a safety concern if you put the magazine in. What possible, why would, what other justification, what justification would there be for saying, no, you can't do that?
So I think safety is a perfectly permissible consideration for the judge to take into account. And we've pointed both to policies from other courts saying even an empty magazine should never be loaded in a firearm when a firearm appears in court. We've also pointed to cases where a judge has decided that if an examination of a firearm is going to happen, it should happen in open court. And here, changing the firearm from the state in which it appeared in the courtroom, I think reasonably could be thought to change the emotional potency of having a firearm in the deliberation room. The whole reason that Mr. Robin is on trial here is for possessing a firearm, and that is criminalized because of the dangerous nature of the weapon.
I don't really get it. I mean, in a sense, anytime you put an exhibit from a courtroom into an exhibit, like back to the deliberation room, you've changed the condition of the object. It's no longer in a courtroom, it's in an exhibit room. But who cares? I mean, what is the rule that pieces of evidence cannot be examined by jurors, cannot be it would be one thing if they were melting it down or something like that, truly manipulating it in a meaningful way. But this to me is like putting the key in the lockbox. It's, a natural thing. Anybody could do it. It's very simple. No reason the jurors couldn't do it on their own, other than like you want a marshal there to make sure they're doing something they're not acting unsafely.
But the fact is that the jury didn't do it on their own, and that's what matters here. We're not challenging the propriety of the jury conducting demonstrations with the firearm in the abstract. The point is, when the jury deliberates independently, when they are back in the jury room on their own in the black box of the jury room and they insert the key in the lockbox, this court is not no court is going to lightly invade the black box of jury deliberations. But when the jury asks a question, when the jury reaches out of its internal deliberative process and asks for help, the answer is different. And I think that's actually clear.
Can I just to pause on that for a second, not to cut you off. But if the jurors hadn't asked at all and picked up the bag and said to the marshal, now, I'm not going to ask you any questions. I know that's not allowed, but I'm going to start inserting this magazine into the gun. And you stop me if that's not allowed. Otherwise, I'm going to do it. And they do it. Do you think that raises a problem?
I think though that exact scenario isn't really materially different than a question, but I do think that the jury asking a question matters. And that's because this court's law is clear, other courts' law is clear that when the jury asks a question, especially about something like this central to its deliberative process, there are procedures that need to be in place for the response to that question. So it is a different scenario when the jury does it on its own.
So take out the verbal communication between the jury and the marshal in my example, and a juror just goes and picks it up, takes the magazine and puts it in the gun. Do you think there's any problem with that?
It's certainly a different case. And
okay, and what do you think about that case?
I think that case is we probably wouldn't be here. I think there's still a sense in which like communications don't have to be verbal, right? And I think there's something potentially about a marshal seeing the internal deliberative process of a jury, what parts of the firearm the jury is looking at. But the question here is what matters. And that's what our claim is. We're not challenging the impropriety of any of these demonstrations in the abstract.
I guess I find that surprising, right? I mean, and maybe I just don't understand enough about how exhibits are displayed to jurors, but you have a gun, which is inherently a dangerous object. And the whole reason that the marshal is accompanying the gun and with the gun in the jury room for the whole time, it's not like he drops the gun off, right? He has to stay in the jury room for the entire time that the gun is there. It's because it's an inherently dangerous object. And I guess I would have thought that you would say that, I mean, the jury asked to see the gun. They didn't ask to touch the gun. They didn't ask to do a demonstration with the gun. And had they done so, presumably that would have prompted precisely the conversation that you think should have occurred in this case, right? So I would think that if having asked to see the gun, they then, took it from the marshal's hands, or, if the marshal put it on the table, grabbed it and started manipulating it, that the marshal would have said something and that would have prompted a conversation that then would take us kind of right back to where we are right now. But maybe I'm missing something.
And I think it's important to go back to the jury instructions here. And what the jury instructions say is that, yes, the marshal has to transmit the gun. So when the jury sent the note requesting to see the gun, it knew exactly what would happen. It knew that the marshal would come back and transmit the gun. And it knew that the marshal would remain there as a silent presence. But the jury is explicitly instructed that it should not discuss the evidence or discuss the case while the marshal is in the room. And to the extent there's a question sort of about, can we see the gun that then happens in the jury room? I think that's just fairly anticipated by the jury instructions, right? That's the point that it's going back. And if the question is there more than one possible response? If it's already been predetermined by the judge with the party's involvement in the jury instructions, that the reason that the gun is going back is for the jury to be able to examine it, then I think we're in the world where that looks ministerial. But the second that the jury is asking questions, which they are told from the jury instructions, that is not to happen, right? We acknowledge that the marshal is there to ensure safety, but the suggestion that then every question that arguably touches on the issue of safety is within the marshal's purview just cannot be correct. And the answer to this question is also different than a question where the marshal had to stop the jury from doing something unsafe. The marshal's decision here did not make the jurors handling the gun any safer.
Well, it did in part by saying, don't put the ammo in the gun, right?
But we know that the question was, can we load the magazine? And the marshal responds in the affirmative about that.
But not the ammo, right?
We don't know from the record whether the jury explicitly asked about the bullets. We know the marshal says no bullets. And I think that no bullets is different because that's an acceptable response in the moment. But still the proper answer is no, I can't do that, but you can ask the judge. And the problem is the marshal having the final say. And when the jury reaches outside the black box of deliberations, that's when it's important that its questions go through the proper channels.
Can I ask you, earlier you referred to like, I think you described what happened when the magazine was loaded, that it made, maybe you can remind me what your words were, but made it more visceral for the jury or whatever. Is that the word you used? Why, that seems, I mean, it might be flipping to harm here, but can you say more about that and why is that a big deal when the jury saw photographs of the gun put together? And that would seem to be a problem in a lot of cases maybe, but my real question is, the thing that interested me more, and maybe I'm getting it from the juror, the affidavit about the jurors or the proffer about what the jurors were saying, is that the jurors seemed interested in either how far it could be thrown, which might be implicit from their interest in throwing the gun, but also the fingerprints, how they would have gotten on them, why they wouldn't be on the magazine or something like that. Are those legitimate considerations for us in analyzing this case, and why?
Yep, I think as Your Honor said, that question goes primarily to harm, and I do want to bracket that our bottom line position is that this was structural error and the court doesn't need to engage in a harmlessness analysis. That said, we don't need to consider the jurors' statements about why it was important, why the toss was important, why the DNA on the magazine was important in order to infer that that's why the jury is asking to see these things, right? The only questions in this case were, was there a toss, and what about the absence of DNA on a magazine, which seems like an issue if this is Mr. Robbins' gun. As for the visceral nature of seeing the firearm in this state, I think it really matters that the jury is told when the firearm is presented in the courtroom, which it is presented the entire time with the magazine outside of the firearm. And the jury is repeatedly
Yeah, can you
told-
point me to why you say that? I read the transcript pages you're citing for that, and none of them were clear. I mean, they repeatedly referred to it there being a receiver in a magazine without any indication of whether or not they were put together or not. I don't think it's contested, so I suppose I take it as true, but do you have anything you can point us to that you think establishes that?
Yeah, on page 157 of the November 10th transcript, the prosecutor is discussing the gun and talks about the magazine is separate from the firearm. That is, I will grant, discussing a photo, but it's clear. So the firearm is broken into exhibit 12A and exhibit 12B, and the discussions about the firearm
I think the magazine and the receiver are 12A and the ammunition is 12B.
Sorry, that's what I meant to say.
Okay.
Yes, the bullets are 12B.
But the firearm's just one exhibit, magazine and receiver.
Right, but they're separate in the bag.
And I'm looking at 157. What are you pointing me to? I mean, it's not disputed. I mean, I take it that, you know, that's probably the normal, it makes sense that that's normally how you would put a firearm in. But on all the transcript pages I saw, I just hear them talking about, you know, there's a receiver and a magazine in there without any indication of whether or not they're combined or not. So I was just wondering why, like, where you're getting that from.
Yeah, it's undisputed that they were separate. I mean.
But do you know where you're getting it from? Is it just a fair inference? Report of a trial lawyer?
So when page 157, it says the portion that you've identified as the magazine is separate. Then the fact that it's undisputed from counsel who were there in the room, both in the new trial motion and then in the opposition, and the fact that when it goes into the jury room, there's the question to insert it, and from the knowledge of sort of what it means for a firearm to be cleared in DC Superior Court involves the magazine being removed. And though that's not clear from the record, I think all of these inferences together, the fact that it's undisputed by the lawyers who were there in the courtroom seeing this happen and the judge who was there, the trial counsel explicitly says in the new trial motion that the magazine was never in the firearm when the firearm was in the courtroom. The government doesn't dispute that in its opposition. It simply says the jury was told why that was, and it's because that's the state in which it was processed. But I think, and the judge also accepts that, right? That this is a state that the firearm was never in the courtroom in the order. And the jury seeing the firearm in that state, which again, that's undisputedly the state that the firearm is in the courtroom, the jury is told that's what it means for the firearm to be cleared. The judge says when the firearm is admitted into evidence, I just want to tell you, the marshals have already cleared this weapon. It's been rendered inoperable. It can't be fired. So there's no risk of that. And then when that state changes, I do think that sort of the emotional potency, the visceral reaction to
Wait, what do you mean it changes? You still can't fire it with a magazine in it if you've got the slide locked and no ammunition in it. What do you mean that, I mean, the state, it's still inoperable. What do you mean? So why is it more visceral that it has a magazine in it?
I don't know that the jury necessarily knows that. And I think it does matter that this is.
You don't think jurors know that you can't shoot a firearm without a bullet?
It matters, I think, that there are courthouses in which even an empty magazine just never goes into a gun. And it matters that the jury, the bottom line point here, right, is that the jury asked a question. We know from this court's case law that there are procedures for asking a question. And the fact is that it's undisputed that those procedures just weren't followed. As soon as the jury asks a question, especially a question that is at the heart of its deliberative process, that question needs to be conveyed to the judge. The parties need to be able to weigh in about that.
So just to understand the parameters of that test, I take it you would agree that if the question were, can I use the bathroom? That doesn't need to go to the judge, right?
That doesn't need to go to the judge. I think as a best practice, like the jury is instructed not to communicate with anyone. The jury is instructed, if you have any questions about the instructions, ask the judge. There are some things that are just so far removed from the merits of a case, as this court said in Etheridge, that any error is going to be extrinsically harmless in an ex parte communication. And the bathroom question is one of those.
Okay. Can I smoke a cigarette here in the deliberation room? Can the marshal answer that one?
Again, I think that's so far removed from the merits of the case. And there's
what's your test?
The test is here. The test only needs to be, because of the way the facts are, the way the arguments are presented, is the communication ministerial? I don't want to suggest that that's the outer bound, because in right to presence cases, the court has also recognized the importance of psychological influences of presence, both on the part of the jurors and on the part of the defendant. So just so I understand what it means to be ministerial, if the question were, can we remove it from the bag? Do you think that is ministerial? Because the answer is obviously yes, or is that not obvious enough? I think that's ministerial because there's only one response because it's been fairly anticipated by the parties and the judge ahead of time. The core question, again, is in the right to presence is like, do you need the chance to be able to participate in the formulation of the response? And that's not really the case. We don't really see that going multiple ways in the question of, can you remove it from the bag? To the extent there are any questions, like in the ground, in the jury room, the better practice is for the marshal to just tell the jury to put any questions in the note.
But I mean, why would he understand this as a question? I mean, there are questions, and then there are sort of things that are phrased as questions, but really just requests, right? Can you pass the salt? Is one where it's not. I'm not asking a question. I would just like you to pass me the salt. And the question, can you put the magazine in the firearm? It's not really a. I wonder if you can accomplish that. It's not a. It is a. Would you do that for us? And he says, I got no problem doing that. Right? That's roughly the extent of his. Yes, that is, I'm here to police the safety of this, and that's not unsafe. I can do that. So let's say he doesn't answer at all, and he just puts it in there. I take it you would have the same argument here, right?
Yeah, I think that the parties and the judge still had a right to be involved in the formulation of the response. And that's why I think that reaching like outside, again, the black box of jury deliberations matters. So again, when the jury is like communicating their deliberative process, not in the four walls of the jury room, but when someone is brought into that, and especially when that's in the form of a question, and here the jury didn't see itself as capable of resolving that question, right? Especially, I think, because there is like the specter of safety, the jury is asking for permission. And in that case, the formulation of the response that needs to come from the judge, the parties need to be involved. But I think it is just the case that whenever there is a communication that bears on the deliberative process, that's when we're no longer, the defendant doesn't have a right to be present, obviously, for the jury's deliberations themselves. That's the essence of the fact-finding function that the jury should be able to do independently in a confidential setting. But when that's no longer confidential, when the jury is saying, this matters to me, communicating that to a non-juror, that's just a different scenario where it matters for the parties to be apprised of questions that leave that black box of the jury room. So I do want to touch briefly on why this is structural error. The error defies harmlessness review because this is a structural error. The formulation of a response to a deliberating jury's question is a critical stage of trial. This court in Hallman has said that communicating with the deliberating jury is as much a stage of trial as voir dire or the examination of witnesses. We know that at critical stages like that, a judge has to preside and counsel has to be present or there is structural error. The federal courts have called formulating a response to a deliberating jury's question a critical stage. The Desir case that the government cites says that a magistrate performs a judicial function by responding to a jury's question that goes beyond the simple performance of a ministerial task, and responding to a jury request for a readback by saying there's no transcript of the testimony that you want to hear back by a magistrate. That went beyond the ministerial, and outright reversal was required. So at critical stages, it's true both that a judge needs to preside and the counsel needs to be present. When both are absent, there's really a structural vacuum and a breakdown of the constitutional protections guaranteeing a fair trial. The structural vacuum caused by the absence of a discretionary decision by a judge is why there is structural error. But even under a harmlessness framework, it's one of the reasons that the government cannot meet its burden to show harm beyond a reasonable doubt. There are simply too many unanswered questions in a world where the response to a discretionary matter never came from the judge. As this court said in Uchenna at the outset of the harmlessness analysis, the court was less concerned about whether a judge reasonably could have given the response at issue than the absence of any discretionary decision by a judge. And the government simply cannot show that the jury's assessment of the firearm would have happened in the same way if the proper procedures for responding to jury questions had been followed and the constitutional protections that accompany a critical stage of trial, like responding to a jury's question, had been in place.
Let's to grant for a moment that, and I don't know if this is true, but let me assume that a judge might have said, no, you can't do that. You can't put Exhibit 12A together. What's the scenario where that would change the outcome here? Like,
Right.
yeah, explain that to me.
So the only questions in this case were questions about whether the toss happened, questions about the presence and absence of DNA on various parts of the gun. And we also know from the demonstrative evidence context that subtle differences in how a jury considers evidence really can make a difference. And that's why in the demonstrative evidence context, courts look to substantial similarity to the actual events. That's why cautionary instructions are so vital, even on differences that might seem kind of minute. And here, one thing that the jury got information about that it wouldn't have had but for the decision that the marshal made and the way that that happened, which we can't guarantee it happens in the same way, is seeing the process of the magazine being inserted. That gives the jury information about sort of the likelihood that DNA gets on the magazine as that process is happening. And again, the question isn't, was that improper in the abstract? The question is, does it happen in the same way? And I think there is this possibility that the judge says no, that the judge says some sort of cautionary instruction is in order. And these are the questions that we'd see if this had happened in real time, if this had come up, if the parties had been made aware of this, if the parties could have been making arguments about how to respond to the jury's question, and the judge had been resolving that question in real time. So it matters here that these questions about the assessment of the evidence are just so much at the heart of really the only facts, the only questions for the jury in this case. If the court has no further questions, I'll save any points for rebuttal.
We will give you
We would ask
2
the
minutes
court
for
for a break.
rebuttal. Thank you.
Thank you.
Morning, Your Honors, and may it please the court, Dylan Alloys on behalf of the United States. Judge Kroll did not err in denying the motion for new trial here and finding that the U.S. Marshal's limited interaction with the jury was a non-substantive ministerial function that did not trigger Mr. Robbins' right to counsel or right to presence at a critical stage of trial.
Counsel, can I just ask you to move your microphone there? Thank you.
My apologies, Your Honor.
Thank you.
And we do agree with Mr. Robin that this comes down to whether or not this is a substantive portion of the trial or ministerial, and the cases bear that out. And I'll refer, Judge Gill, you were asking about what the test is. The Supreme Court's case in Gagnon, that's Gagnon, says whether a defendant has a right to presence, whether this right is triggered, turns on whether or not what is occurring at trial relates reasonably substantially to his opportunity to defend himself. So there has to be something substantial, something substantive happening as opposed to something ministerial happening. Now, I do want to push back on what Mr. Robin was describing as the nature of the discretion, I believe as it was put, that the U.S. Marshal was supposedly exercising here. I don't think there's any support in the record that suggests that the U.S. Marshal was acting in any type of discretionary way. He wasn't, for example, assessing these 12 jurors and saying, well, a jury with Judge Deal on it, I would not trust them to touch that weapon at all or put a magazine in. But, you know, a jury with Judge Beckwith or Judge Easterly, I would trust them to go do this.
Do you think that the marshal followed the instructions that the jury was given about what would happen?
So the instructions being that the U.S. Marshal will come in,
Yeah.
bring the firearm, and will remain there for security purposes while you examine it. I believe that what was, to use the words that Mr. Robbins said, what's fairly anticipated is that the jury is going to be, an examination would require handling the firearm if they so chose to do that. And that for security purposes, what the marshal's presence was there was to make sure that that this deadly weapon was handled safely.
So the reference to do not, I mean, I realize this is an instruction to the jurors and not the marshal, but I forget what it says, but do not talk, basically don't talk.
Right, so you should not discuss the evidence when the marshal is present. That's deliberations, right? And there's nothing in the record that suggests that they, while the marshal was present, sat there and deliberating amongst themselves, well, do we think the toss could have gone this far or happened this quickly? We know that while the marshal was
So
present.
the difference is discuss is sort of like they have to be having an actual deliberations about it as opposed to asking a question about the evidence.
Well, discussing the evidence, I think the reasonable inference is that's a fair proxy for deliberating. And that reinforces the earlier instruction, which is do not deliberate or discuss your deliberations outside of the
What's
jury room.
I'm sorry, I'm missing the dividing line between discussing and deliberating.
So discussing the evidence, I think it is exactly what it means here is deliberating. Don't deliberate with the US Marshal present. Don't, you
But
can
but
examine.
it's okay for the jury under this instruction to pick up the gun and remark to their fellow jurors, wow, this seems heavy. It's bigger than I thought it would be. You know, it seems hard to imagine this fitting into the back of someone's pants, you know.
So.
Does that, is this third statement the dividing line, but the wow, this seems heavy, this is big, that's just discussion, that's not deliberation?
No, so I think picking up the gun is covered by this. What the other statements remarking, wow, this is heavier than I expected. I can't throw this as far or as quickly as I did. That all would be substantive discussion of the evidence, deliberations. I don't think there's a dividing line here about deliberations and discussions. I think it is the same thing. I just want to be clear on that, but I don't, what I do want to push back on is the understanding that the US Marshal's entire role in being there with this lethal weapon was to make sure that it was handled safely. Ensuring that, hey, Mr. Marshal, we want to be able to put the magazine in. Is that allowable under your safety supervision? And the marshal will be saying, yes, but you can't put these, you can't load it with live ammunition.
Let me push back on that. Why is it, as we understand correctly, the normal protocol that the receiver and the magazine are generally separated?
In the way that
For
it's.
safety reasons, right?
Well,
I mean, because, it's possible, maybe I don't know enough about guns, but it's possible that you might think that all the bullets are out of the magazine, but they aren't.
And that's the.
Right, we keep them separate for safety reasons. And the
Well-
marshal's in there for safety reasons, and then he does something that seems less, he seems to give the jury permission to do something that is less safe.
So I'll push back on that characterization. So certainly when this comes into evidence, and we're not going to dispute that that the magazine and the firearm were separated when they were physically entered into evidence. But the fact that the marshal had cleared the weapon when it was first.
I'm sorry, I missed what you just said. You're saying you are not conceding that they were
No,
separate?
we're not contesting that.
You're not contesting.
We're not
Sorry,
contesting that.
I'm still having a little trouble hearing. you.
My apologies, Your Honor.
Okay.
But the fact that the marshal would allow for the empty magazine that he has inspected, right? He was the one who transmitted this evidence to the jury. The fact that he would allow an empty magazine to go into a receiver without any live ammunition is proof in and of itself that this was not something unsafe. If it were unsafe, he wouldn't have allowed it to happen. His entire role there was to ensure that the jury was safely handling the
I mean,
weapon.
how do we, that seems, what's the Latin phrase, ipso facto? I mean, anything that he does has to be safe because he's there for safety purposes. I mean, that just seems tautological and patently can't be true. Right? If the marshal said, sure, go ahead, you can point the gun at somebody else's temple, no problem. That would not seem to be in furtherance of safety, but under your argument, because he's there for safety purposes and he is the final word on what's safe, that's totally fine.
So here again, when we're talking about a firearm and firearm evidence that has been cleared by the marshal that has no live
I understand
ammunition
the
in it.
particular facts, I'm just sort of pulling at the threads of what you're saying his role is, and you seem to be saying that anything that he says is safe must be safe because he said it was.
Limited to the facts here about the empty magazine, I think that's the case. If we have a rogue marshal, which I don't think there's anything that suggests that's here, that say, sure, load it up, point it around the room, see if the
But
trigger
that just
works.
gets back to my question about why was it safe? I mean, if the general rule is we don't put magazines in guns in courthouses because we recognize there's always a risk, there's always a danger. Why is it safe for him to say you can put the magazine in the gun? That seems to be beyond his safety role. And certainly was permitting the jury to assess something of factual significance. I mean, the only reason they asked was because they were deliberating. They were trying to figure out what they thought of the government's arguments.
So the assessment of this evidence, right? So there was both the photographic and the video evidence and testimony that this gun was loaded when it was first recovered. So this is not going beyond what the jury understood. They knew that this gun was not recovered from underneath the car after Mr. Robin tossed it with the magazine out of it. It was loaded inside of it. So what they were doing is consistent with the theories of the case that the parties put forward. As far as examining the evidence, and I'll respectfully direct the panel to footnote 12 in the accompanying text, which is.
If the jury had said in a note, we'd like to see the gun. We know it was displayed in court in 2 parts. We'd like to put the parts together and we'd like to do a demonstration of that for ourselves and toss the gun to see how far it could go. Do you agree that the judge should have been the one who answered those questions? It would be wrong for the courtroom clerk or the marshal to answer those questions, right? And it would be wrong for the defense not to be apprised of that note and to be able to give information about how to respond to that note.
I think if the jury is asking about the scope of what it is allowed to do as specifically related to the deliberative process and seeking the judge's input on that, then this court's case law, USADA, for
So for
example.
my question, the answer is, yeah, that would be wrong.
It-
And I'm just trying
correct.
to figure out what's different about these facts.
So the jury wasn't seeking guidance on the mode of its or what it's permitted to do as far as its deliberations go. It was seeking guidance on safely handling this firearm. And I think Judge Deal's the hypothetical Judge Deal gave about the lockbox is fair here. If, for example, the U.S. Marshal would not have to accompany a lock and key bag, if the jury wanted to ask the courtroom clerk, can we put the key into the lock? I think that would need to go to the judge, just like the example you gave. But if the jury took it upon themselves to say, both of these were in evidence, we're trying to figure out if this key unlocks the box.
Yeah, I guess the
there-
difference is for the lockbox, presumably the marshal isn't in the room, right?
That's correct, but
Deliver the lockbox, you deliver the key, you leave the room. What happens? You're not part of it.
But
And I think Mr. Robbins' argument is, wait a second, the marshal was there and sort of facilitated this whole scenario.
facilitated based off of the understanding of the parties because they knew the marshal would go back. That was what the instruction was. The marshal, they knew that.
They knew that the jury wanted to see the evidence and they knew the jury had been instructed not to talk about the evidence with the marshal.
Right, so we are not going to deliberate about the evidence and there's no reason to believe that the jury ignored that instruction and went there. And I do also want to get back
There's
to,
no reason to believe, I mean, in the motion for a new trial. I mean, there was never a hearing. I
That's
think
correct.
Mr. Robin asked for a hearing. Is that correct? No?
I did not read that in the motion, Your
Okay.
Honor.
All right. So, but the facts are not contested.
It
Right.
the
And so
affirmative, yes.
the facts such as we know them is that the marshal brings back the firearm. The juror asks the marshal if they can put the magazine in the gun. The marshal says yes and does so. And the juror, at some point, somebody expresses interest about how the DNA on the firearm could be on the firearm, but not on the magazine. And they do the demonstration. And I guess you're suggesting to me that the demonstration occurs in complete silence.
There's no,
I mean, that just seems implausible, right?
Your Honor, if they were deliberating and Mr. Robbins' counsel or investigators had found out from the jury that they were deliberating with the marshal or in the presence of the marshal, I believe that that would have been presented.
I mean, you agree that if they were doing the demonstration and saying, okay, who's gonna, throw the gun? Okay, I'll stand over here. This is where the car is, and had that sort of conversation, that constitutes deliberation in your view, right?
If they're
We talked
discussing,
about deliberation and discussion before. That's deliberation.
if they're discussing about the merits of the parties' arguments based off of the evidence and asking about whether or
Right.
not.
And so you're positing that in this scenario, we just think that none of that conversation happened while the marshal was there.
Well, based off of the factual, the averments that the court said we will accept is true, there was nothing put forward by Mr. Robbins' counsel that says that the jury was deliberating there. But I also,
But if they did, who cares? I mean, the claim of error is not that jurors discussed something.
right, and
In the
Mr.
marshal's presence, and that wouldn't be grounds for reversible error anyway. Jurors can violate their instructions.
And Mr. Robin would have no right to present, as he conceded, would have no right to presence during deliberations anyways.
And it's a kind of error that if that were really the error, why wasn't the defense on notice of that? I mean, if they wanted to say in response to the jury instruction, Judge, if you're sending this marshal back there with a gun for an examination, sort of in a similar thread that Judge Easterly is thinking, inevitably that's going to involve some commentary. Whether you call that discussion, deliberations, who cares? They're going to be talking about something. They're not going to do this in silence. So we want that to be done in open court with us present, right? That was an option, but nobody asked for that.
Requested that. That'd be like the Sobawamo case in the DC circuit, but they did not request that despite having full knowledge of this instruction. And if they wanted to argue to the jury about, hey, when it goes back, this is going to be in a different state than what it was on the crime scene, and you're not going to be deliberating in a parking lot, you'll be deliberating in a jury room. All that was fair game for closing argument. In fact, when they knew that this instruction was going to be read to the parties, they knew that was fair game for closing argument. They didn't. What they want to do here is to have a second bite at the apple to say, well, the fact that the jury actually took us up on our offer and wanted to test our theory of the case and decided, in fact, our theory of the case doesn't hold water is not a reason to reopen this or not a reason that there was a constitutional violation here. And I want to get to the three things that Mr. Robin posited could have happened. The parties could have argued further. Well, he had a chance to argue that in closing arguments, knowing full well that the evidence was here, that the gun, the magazine, and the bullets were all in evidence, and that the jury, there was a function for the jury to be able to request to examine that. So that doesn't hold water. The second is this could have been done in an open court. They easily could have asked for that when the jury instructions were there, and the Judge Kroll could have said, no, I don't think it should happen in open court, or he could. But the fact was they already had the opportunity to do that, and nothing about the U.S. Marshals limited safety instruction is reason to revisit that tactical decision in the Rule 30 conference. The cautionary instruction. Now, Judge Kroll has said, I wouldn't have given that cautionary instruction. That's what his order says. Judge Kroll says, I would have allowed everything that happened here to happen exactly as it would. Now, that's going to be part and parcel of the harmlessness analysis, but it also suggests his presence wouldn't have meant anything. And
There's a flavor of self-justification when judges say things like that, though, right? Where, I mean, trial judges have an interest in preserving the trial that they've seen go through a verdict. So when they say, I don't know if the confirmation bias is quite the right phrase here, but when they say that none of this would have mattered to me, I mean, we don't have to take that at face value. We could say, well, Judge, of course you're going to say that. You don't want to be reversed, and you want your verdict to be upheld, but you really can't put yourself back in that position. You're really not thinking about whether or not you would have let this happen, because you're not in the moment anymore, and now you have a reason to try to justify what happened.
I would not say that Judge Kroll's 10-page order, which goes through case law and provides the justification and reasonings for how he would have ruled, is pretextual. I wouldn't suggest.
I don't mean pretextual sounds like I'm ascribing some insincerity to him, and I don't mean insincerity. I mean sincere, but possibly wrong. Like people just can't put themselves in like the ex-ante situation, especially when they have an interest in what the correct answer is. People often just justify, what has already occurred.
Sure, but to peel back and I know that I'm out of time, I would like to address the structural argument, but just to peel this back just a little further. In the context of giving the cautionary instruction that Mr. Robbins said he would have asked for, would involve effectively instructing the jury on one party's theory of the case and very heavily putting the judge's thumb on the scale of deliberations. Hey, when you toss this around, really remember it's a lot, it's potentially lighter than what it was there. Remember, it's in a carpeted room. It's not out in a parking lot on gravel. Keep that all in mind. That is almost saying to the jury, you really should discount what your own evaluation of the evidence is. And that comes awfully close to putting your thumb on the scale, or perhaps even does. So there's very good reason for a trial judge in dealing with the very sensitive issues of jury deliberations in this context of asking for, basically giving a party argument as a curative or whatever, as an instruction, to not want to go there. And but that again is what Judge Kroll's justification was for saying I would not have entertained that. And that also is not what is at issue here, because what is at issue here was not the U.S. Marshal making any kind of decision like that about a further instruction. With respect to structural error, Mr. Robin points your honors in the correct direction of the Hallman case. The Hallman case explicitly asked whether or not this was a clerk unilaterally responding to a note, and they said, the appellant in that case said, this is per se structural reversible error, and this court explicitly said it was not, and then went to go and review it for harmlessness and said, we find this to be, we're going to affirm on harmless error. So this is not structural error. And I'll point your honors to the Uchenna case, in which a very thorough analysis about whether or not the right to presence was harmless error, and says in all of these cases, in all of our precedents, we apply harmless error to do this. So in no event here is it structural and per se reversible error. And to get to the point also, I know Mr. Robin, although didn't invoke the case, the Fulminante case from the Supreme Court, talking about whether you can, harmlessness is anathema to being able to, or excuse me, structural errors are anathema to being able to evaluate harmlessness. All of these court's cases, this court's cases, Hallman, Uchenna, Roberts, evaluate harmlessness in these explicit situations. And so based off of Hallman, based off of this court's precedents, it's not structural per se reversible error. It should be evaluated for harmlessness. And the reasons to not reverse for harmlessness here are very strong, as we lay out in the brief.
And
Judge
if you apply harmless error analysis, do you see it as Chapman?
If there's a constitutional violation as opposed to just a Rule 43 violation, then yes, it would be Chapman harmless error. But Judge Kroll, and more to our discussion earlier, Judge Kroll said everything that Mr. Robin talks about what he would have wanted with presence or with me presiding would not have changed anything. The jury was well within its, its rights to inspect this evidence exactly as it wanted. The U.S. Marshal, in fact, did not stop the jury from doing anything that it wanted. The jury asked to put an empty magazine into a gun in order to toss it, and the U.S. Marshal allowed them to do exactly that. There's no facts and evidence that suggests that the jury wanted to do something more, that the U.S. Marshal said, whoa, you can't do that. I am stepping into your deliberative process and saying that is not permitted. That's not this case. Again, we list all of our cases in footnote 12 saying that what the jury did with this gun, with the magazine and the firearm in evidence, is all fair game for how to test the party's theory of the case. The Judge Kroll recognized that. He cited the DC Circuit's Hawkins case for this exact proposition, and it follows directly from Mr. Robin's arguments and both parties' closing arguments in this case about what this comes down to. So all of that, it goes to show that even if you were going to say there's error here because it related somewhat substantially and reasonably substantially to Mr. Robin's opportunity to defend his case, the result would have been the same. And we know that from Judge Kroll's order here. So we would submit, even if you do find this is error, it's not structural and should be affirmed for harmlessness. Unless there are any further questions, we would ask this court to affirm. Thank you.
Thank you. Ms. McDonald, we'll give you a couple of minutes.
Thank you. I would like to start, I have a few brief points on rebuttal. I'd like to start where the government started, invoking Gagnon, and that's a case that doesn't happen during the crucial fraught moment of jury deliberations. And so when the government says there has to be something substantive happening in order for there to be a constitutional right to presence violation, we know from this court's case law that that's not true. And we also know that communications that happen during the fraught stage of jury deliberations, when the area is so sensitive, when what is said matters so much, that those cases are treated differently. That's an area, as the court has said, communications with a deliberating jury are pregnant with possibilities for error. And so even questions from a jury like, can we have a copy of the jury instructions? That's error under this court's law. The error is the fact that the jury received a response to its questions without the procedures happening in the proper way, without the response coming from the judge, without the parties being able to be involved in the formulation of the response. And the court has not ever found no error in a case where a communication to the deliberating jury didn't come from the judge, didn't happen with the involvement of parties and counsel. And we have the process of jury notes, the fact that responses have to happen with the party's input in order to deal with issues that come up. Not everything has to be anticipated. And that's why we know cases like Wilson, where this court says, when there is an inquiry from the jury, here are the procedures that have to happen. The error here, the constitutional error, and here's in those procedures not being followed. When it comes to the question of harm, the government accepts that if the jury is asking a question because of figuring out its deliberative process, that's a different case where we have a constitutional error. And once the error is established, which it is here, that the response didn't happen in the right way, it's too speculative even to know why the jury was asking to load the magazine. The government draws this false dichotomy between the question about tossing, the question about loading. Well, we know the question about loading is important to factual issues in the case, and we know that tossing could maybe involve safety issues, right? So this idea that loading the magazine had nothing to do with the deliberative process just isn't true. I want to respond briefly then to the government's point about Holman and structural error. Structural error in this context is not at all foreclosed by this court's case law. In Holman, the facts were that a note was discovered where the response said, the jury asked for a copy of the jury instructions. There was a response that said, no, but you may ask for any portion of the instructions to be reread in open court, signed Clerk Powell for J. Hamilton. So there's an argument raised in Holman that the assumption of judicial authority by a non-judge, by the clerk, is structural error. And the court says that's too speculative. The parties are vigorously, that's too speculative on the facts. The parties are vigorously disputing, did Clerk Powell for J. Hamilton mean that the response came from the judge? Even in that scenario, Holman is unequivocal in saying still error because the parties should have been involved in the formulation of a response. There's still a right to presence. But Holman says this assumption of judicial authority argument here is too factually speculative. So rejects that, sets that aside and says the only argument that we are left with is this Rule 43 argument. Courts assess Rule 43 cases for harmlessness. And in this case, we just don't have that similar factual uncertainty. It's undisputed that the response here did not come from the judge in any sense. And our structural error argument, I think, rests primarily on the absence of the judge. The absence of counsel follows from that. And those are when UCEDA assesses for harmlessness, it does so after explicitly raising the fact that structural error was not raised by the parties in that case. The only argument there also was a personal right to presence violation. The court in UCEDA says the fact that there's no judge presiding, there's no counsel involved at what looks very much like a critical stage in the formulation of a response to a jury's question during the fraught moment of jury questions, that raises some structural error concerns, invokes structural error cases, but says we are presented with no argument here. And in the cases like Roberts and UCEDA, where, as the government says, the court is assessing for harm, I think it's important that the harm analysis, again, structural error not raised in those cases, but the harm analysis really is focused on, like, it's just too, it's too counterfactual to unwind like what the judge would have done, that the absence, as the court in UCEDA said, of any discretionary decision by a judge is the primary concern. And it's just too difficult for the government to meet its burden to establish harmlessness beyond a reasonable doubt in a case where there was a matter that was vested to the court's discretion, and the court never gets the opportunity to exercise its discretion. And so this entire structural vacuum where the court is entirely cut out.
Do you think in any of those cases, I just don't recall, do we have the trial judge on record saying what they would have done? Which we have here.
Not so in UCEDA, I think it's telling the way that the issue came to light in UCEDA was on appeal, and then there is a
Right.
remand for a 10C hearing. The question that was asked of the trial court there is never how you would have handled this. And that's because of Milton Davis. That's because it is the role of the appellate court to assess harm. And after the fact, so the government again points
Well, I
to
mean,
these.
it's true that it's our role to assess harm, but very rarely is the question of harm so tied up with what a trial judge would have done in the situation as it is here. So I'm not sure, is the answer no, none of those cases? Do we have an indication from the trial judge what they would have done? I take it that your other position is, well, that shouldn't matter so much, and that might be right. I'm just wondering if you think that any of those cases involved in it where we disregarded what a trial judge said they would have done.
I do think, I'll say again, I think it's telling that in UCEDA, that's never a question that's asked, even though there's a specific remand for an evidentiary hearing. We're never trying to glean what does the trial court say he would have done. Johnson, the Chris Johnson case from 2002 is another case that arises in a new trial posture. And there, the trial court sort of purports to assess harmlessness. This is a case of two substantially similar jury notes. One of them problematically doesn't make it to the attention of the parties. There's or the judge, because the clerk sort of screens it out, probably wrongly, as a question that sheds light on the jury's split. But there, it is a new trial motion. The court purported to rule on harmlessness, but the court conducts its own harmlessness analysis and isn't deferring to what the judge would have done. And I just think that it has to be logically the case that this court doesn't rely on Judge Kroll's statements in the new trial motion, which I think aren't even themselves, this is exactly what I would have done. But just answering this question when what is at stake is holding the 4-day trial over again is so different than answering the question on the ground. What is the proper response to this jury question is different than does a new trial need to be held after the fact because of this? And the fact that the judge might have permitted it if he had heard arguments from the parties about the permissibility of it, I think shows like he had discretion to permit it or not. And so we just can't unwind it and try to determine what would have happened had we had different arguments from parties. Potentially, even once the jury note is committed to a note, it ends up looking different than the question that's asked verbally. And so there are just too many unanswered questions to determine that this would have happened the same way. Because this was so central to the jury's deliberations and the government can't show that it would have happened the same way, it cannot be harmless beyond a reasonable doubt, even if that is the framework under which the court addresses the question. And so for these reasons, we would ask the court to reverse.
Thank you very much. Thank you both for your briefing and your arguments in this case, and we will take it under advisement. Second case on this morning's calendar is number 24 CV 420, Uchenna Egenti versus Gateway Market. Whenever you're ready.
Good morning and may it please the court. Fran Swanson for appellant Uchenna Egenti. I'd like to reserve 3 minutes of my time for rebuttal. There are 3 issues in this case: the actual basis for the trial court's ruling and 2 alternate bases for affirming proposed by the landlord. The trial court ruled that 2 housing conditions court cases precluded Ms. Egenti from bringing a contract claim for damages covering longer periods of time. That's wrong because the previous cases involved different claims covering different periods of time. The landlord makes no attempt to defend this, and it must be rejected. Instead, the landlord urges affirmance first on the basis that a different civil actions branch case is preclusive. But that case could not be preclusive because there was no judgment on the merits. It was dismissed without prejudice as moot. This court has repeatedly held that, quote, a decision on the merits is required to apply claim or issue preclusion. Second, the landlord argues that this court should affirm on the insufficiency of the complaint. That's wrong. The elements of a contract claim are the existence of a contract, the violation of a contract term, and damages. The complaint alleges a contract because it alleges a residential lease. And all leases in the district include an implied warranty of habitability, which is breached by violating the housing code. That's the Javins case. That warranty is violated.
Does Javins refer to a breach of the implied warranty of habitability as is that a breach of contract claim?
Yes, Judge. A breach of the implied warranty of habitability is always a breach of the lease, and that's what the Javins case says. So that warranty is violated by a pest infestation and not having hot water. That's 606.1 and 400.3 of the housing code. In fact, this court has held that the lack of hot water by itself states a claim against the landlord. I'd point you there to the Winchester Management Corporation case versus Staten. And here the complaint alleges that the landlord violated this warranty. The complaint also states a harm to Ms. Egenti and her minor son who lived in the unit with her. And it's irrelevant that her complaint lists a certain amount of damages. We know.
Did the complaint mention her son? I'm just.
Yes, it did, Judge. So the complaint appears at JA 111.
Right.
And here she says, I'm requesting damages in excess of $75,000 plus any additional costs and damages that may be occurred. And above that, it says plaintiff's disabled minor autistic son lives with her and has been negatively impacted by the defendant's failure to address these concerns. And the trial court itself actually spoke to harm when the landlord attempted to argue that no harm had been alleged. And the trial court said, there's a pest infestation. That sounds like harm to me. And so this is a classic and basic contract claim. She did not, it didn't need to be a long complaint in order for it to be.
I'm sorry, I'm looking at my notes on the complaints. I'm not looking at the actual complaint, but in the first paragraph, she mentions her son. Is that what you're saying? There are 3 questions in the form complaint.
Yes, Judge.
And I see where she says she wants $75,000 of damages. Where does she say mentioned her son?
Yes, so she mentions her son in the answer to the first question. That appears at JA 111. And I can quote from it here. Quote, plaintiff's disabled minor autistic son lives with her and has been negatively impacted by the defendant's failure to address these concerns.
Okay, so you've mentioned the pests and the hot water. The court, the complaint also mentioned stalking, right? Is that right?
Yes, and noise.
And noise. And the court does seem to, although it rules on preclusion grounds for everything but the stalking. On the stalking claim, the court sort of gestures at a 12B6 ruling and says, I don't really see a connection to the landlord. He's speaking to the landlord's lawyer. So he says, I don't see a connection to your client. And then at the end says, I'm ruling on preclusion in 12B6. So I didn't see you contesting that ruling.
Correct, Judge. Ms. Egenti has decided to not press that claim on appeal. There was also a noise complaint that the judge dismissed for non-preclusion reasons, and Ms. Egenti is not pressing that claim either. It's just the hot water and the pest infestation, both of which are breaches of the implied warranty of habitability.
I'm not seeing it in your briefs. Can you give me a citation for the Javins case that you're relying on for breach of implied warranty of habitability is properly couched as a breach of contract?
Yes, Judge, I'm not sure that we cited the Javins case in our brief, but the landlord doesn't contest that a breach of the implied warranty of habitability is a breach of the lease agreement.
Do you have a citation for me?
Yes.
I also don't recall that particular argument being made in your brief. So if you want to point me to that, because if you're going to say they've conceded the point, it would help for me to know where you made the argument.
Yes, of course, Judge. So the Javins case, I don't have the reporter site for that, I'm sorry, but I will look to where we made.
Could you spell it for me? Is it Javins?
Yes, of course, Javins, and that's
Okay.
versus First National Realty. And this court
And that's one of our cases.
that's a DC Circuit
DC
case.
Circuit case. Okay.
But this court has repeatedly held that a breach of the implied warranty of habitability is that the implied warranty of habitability is included in every residential lease in the District of Columbia. And so when the landlord violates the housing code, that constitutes a breach of the implied warranty of habitability and a breach of the lease. So it may be helpful here to discuss the purpose of the Housing Conditions Court, to just explain why preclusion here was error. So the only remedy that you
Well,
can
if the
get.
landlord hasn't argued it on appeal, do we need to get to the condition ruling? Right? I mean, it seems like the landlord is arguing preclusion for a different reason.
Mhm.
And we can talk about whether that has merit. But I would think that until you get up on rebuttal, unless the landlord pushes preclusion on the housing conditions case, you can take their failure to argue preclusion on those cases in their brief for what it is. And so let's talk about the things that they've actually contested.
Of course. So I agree that it was forfeited by the landlord and the court could decide it on that basis. But I do think that because the trial court made this error, it's something that could be an important point for clarification. But yes, I'd be happy to answer further questions on the arguments the landlord makes.
I mean, we generally don't like to reach issues that aren't being really grappled with by the parties in the briefing. So if they're not arguing about that preclusive effect of the housing condition cases, then this case really hasn't joined on that issue. They're arguing about the preclusive effect of the civil case.
Yes, Judge.
And so if you want to talk about that, that might be helpful.
But before you get to that, can you tell me if your opening brief focuses entirely on these preclusion issues? Is that right? Do you make an argument in your opening brief that your client has stated a claim?
So that was not the basis for the trial court's ruling on the breach of contract claim. That was only the basis for the ruling on the noise complaint and the stalking incidents. And so that's why we make those arguments in reply when the landlord urges that as an alternate basis for affirmance.
So you don't envision us reaching that question?
Yes, well, the court could, I'm sorry.
No, go ahead.
Yes, so that was not a basis for the trial court's decision. Of course, review is de novo and the landlord has urged that as an alternate basis for affirming. But here that's unsupported. A residential lease is a quintessential contract. There's a quintessential contractual relationship between the landlord and the tenant. Ms. Egenti said that the landlord failed to provide her with hot water, allowed there to be a pest infestation, and that constituted a breach of the lease. And the landlord, beyond a passing sentence in their brief, doesn't explain why it was insufficient that Ms. Egenti her complaint alleged these things.
But just to put a finer point on Judge Beckwith's question, are you looking for a ruling that says the court was wrong to dismiss this complaint on preclusion grounds and this complaint survives 12B6? If so, I don't really see that the second part of that has been briefed. Or are you saying you want this court to say the court was wrong to dismiss this case on preclusion grounds, and this case should be remanded for further proceedings.
I think that this court, because the landlord has urged 12B6 as an alternate basis for affirming, can and should address the question of whether or not the complaint satisfied the 12B6 standard. And I think that that's an easy
I mean, it's
question.
just that, you know, I understand why your brief was written the way that it was. But once they bring up 12B6 as an alternate basis, it just looks like your reply brief, which really has, you know, 2 pages on this and doesn't cite Javins, isn't sort of a full-throated, hey, you should say it survives 12B6. It's more in the nature of, hey, don't affirm on other grounds. That's how I'm reading your brief.
So we do address the question at page 4 of our reply brief. The landlord never made an argument that a breach of the implied warranty of habitability was not a violation of the lease agreement. And so our brief didn't go in depth on that. Instead, what the landlord argued was essentially that the complaint doesn't, quote, does not plead that Gateway had an obligation or duty related to the claim or, quote, indicate what contract exists. That appears at pages 6 to 7 of the landlord's brief. And in our brief, we said that Ms. Egenti's complaint identified Gateway as her landlord, which is an answer to the first argument that the landlord made, and then stated multiple ways that as landlord, Gateway had violated its lease agreement with her. And so I think that's sufficient to address the arguments that the landlord made in its brief. Of course, if the court disagreed, it could remand for further proceedings, but I think that's unnecessary. And I think that it would be unprecedented.
We have to remand for further proceedings if the complaint is not dismissed, right? So
Yes, of course.
Yeah.
I think that the court could reject the landlord's argument urged in its brief that the complaint was insufficient to state a claim because they have urged that as an alternate basis for affirming. So I think the court can answer the question and say this complaint was sufficient. You know, it's very common for unrepresented tenants bringing claims against their landlords and unrepresented people generally in the district to bring complaints that are not long, that use the limited form complaint that the courts provide to them, but it's certainly sufficient when they state the elements of a contract claim. And I don't see any argument in the landlord's brief beyond saying she doesn't identify who the defendant is and what her relationship is. I don't see any argument urged by the landlord that really questions that. And I think rejecting Ms. Egenti's pro se complaint on those grounds is insufficient would have a big effect on many unrepresented people in the district who simply use the forms that the court provides them with. If the court has no further questions, I'll reserve the rest of my time for rebuttal.
Okay, thank you very much.
Good morning, Your Honors. Matthew Moore here on behalf of the appellee. Want to probably move around a little bit because I think I'm unsure of some of the statements made by appellant's counsel. So I'll address the 12B6 issues first. I don't see in the complaint at JA 111 where Ms. Egenti filed pled a claim for breach of warranty of habitability. That seems to be entirely the argument or a big portion of the argument as to why this claim does state, complaint does state a claim for relief. But that cause of action is nowhere there mentioned. Additionally, as to the breach of contract claim, I don't know that there really is any case law on this, but definitely from personal experience, tenancy can be formed without a lease. So just a statement that.
I mean, really, she attached something to her complaint, right? And it said, I think it was a transcript from a different case that indicated that there is a lease in this case. I just didn't see that that was disputed. Did you dispute that in the trial court? I know you made your 12B6 arguments full-throatedly, right?
Yes.
And the court notably had zero interest in them except as to the stalking claim, which the court said, okay, that I don't see a relationship to your client on stalking. But other than that, it seems to me the court recognized it's a form complaint, it's a pro se plaintiff. You know, this is gonna pass muster, and the court went in a different way on the preclusion ruling to dismiss the case. But do you want to show me in the record somewhere where you actually contested that she was a tenant? Or that
No,
there was
we
or
definitely-
that there was a lease?
We definitely, I believe we did plead in our motion to dismiss that she failed to provide details about.
You said that she didn't provide the exact paragraphs of the lease that had been violated. But, you know, if this is all implied warranty of habitability, then, you know, I don't even know that there needs to be an exact paragraph in the lease. I mean, we just know, everyone knows that you have to provide hot water and you can't have a pest infestation in a rental property. So, you know, she didn't use the fine lawyerly language perhaps in her form complaint, but again, she's pro se. I think everybody kind of knew what she was talking about, which is why the court declined your request to dismiss this on 12B6 grounds, those two claims.
I will move on from that argument, Your Honor. Then,
You have a preclusion argument, but it
Yes.
doesn't seem to be the preclusion argument that the court made. The court was talking about the housing conditions claims, and you seem to think that the court, and you don't defend the court's preclusion ruling on the housing conditions
no, Your Honor.
cases. You're looking to the civil case.
Yes, Your Honor. Actually, though, the housing conditions case do play a factor in the preclusion brought on by the civil case. Because at the time the civil case was filed, Ms. Egenti was well aware of the claims of these same claims that could have been brought in that prior civil case. And to be clear, the argument that we should have more clearly made and are clearly making today is that it is claim splitting, which is a part of the doctrine of res judicata. And if we examine closely the judge's ruling, Judge Lee's ruling, and the pages therein, also, I think we need to start as to what Judge Lee had knowledge of. On the back of the form complaint we were just going through, Ms. Egenti mentions the civil case, which is CAB 2023 CAB
Right, the court.
4157.
We're aware of the civil case, but all of the discussion at the March 1st,
Not by Judge Lee.
2024, well, okay, I understand that you're referring to the fact that he cited the civil case number. But you have to read what he says in context, right? So he's saying, you know, in the breach of contract claim, that's clearly something that could have been brought in these other cases that you have, because it relates to the very same subject matter of the previous cases. And he's referring to the housing conditions cases that he's talked about. And you know this because he then says, the rodent infestation, the absence of hot water, those are housing code violations for which you filed 2 separate cases. And then he gives the case numbers for what he thinks are the 2 separate cases. And he says, one is the one that I referenced, which is 23 CAB 1833. The other one, and this is where he makes a mistake, he says, is 23 CAB 4157. But he's talking about the housing conditions cases, and he mistakenly talks about the civil case. Now you can disagree.
I disagree wholeheartedly.
Tell me where else, other than that one reference to that number, we would think that he's talking about the civil case. Why? He hasn't said a word about the civil case other than that.
Because the complaint, the judge has read the form complaint, both pages, Ms. Egenti references that. He references, these clearly something you could have brought in these other cases.
These two cases, the housing
Your Honor.
cases.
Your Honor,
Okay.
if I can
Let's
finish.
assume I agree with you, and I think that the civil case is what he was talking about, even though he hasn't breathed a word about it in the hearing up until page 11 of the transcript, when he mistakenly seems to have referenced this number. But let's say I agree with you. Why is a case that is dismissed on mootness grounds, why would that have preclusive effect?
It's still a dismissal. It is a final decision.
Right.
And the
But a
issue of,
dismissal for mootness is a dismissal for lack of jurisdiction. And we have said a dismissal for lack of jurisdiction is not preclusive.
but the point of claim
Do you have any
splitting,
law to say otherwise?
not with me here today, Your Honor. I I do have Gills versus Ware, decision by this court in 1992, 615 A second 533.
Is that cited in your brief?
No, Your Honor, it is not.
And you're.
Sorry, what's the case cite again?
It is 615 A second 533. The court does not extrapolate on the requirement of dismissal. It actually, in that case, I do believe I've seen other cases, it does say final adjudication on the merits.
But it's not on the merits. That's the point.
But these are claims,
It's dismissal for on mootness. So it's not on the merits. It's a jurisdictional
Yes.
determination.
Your Honor, it is. So as to those are arguments which are 12B6 dismissal because she failed to state a claim for relief, adequate claim for relief, setting forth how she was damaged.
Have you made any argument that she has waived the 12B6 claim?
No, Your Honor, I have not made any argument, but I believe that by failing to seek to amend her complaint, she has waived the argument that she should be allowed to amend. I believe, I don't think Judge Lee specifically gave her leave to amend, but the rule requires that she file a motion for leave, file an amended complaint within 21 days of Judge Lee's ruling. I know she did not appeal this matter until after the 30 days had
Judge-
passed.
I mean, does she have to file an amended complaint as to the claims that he said were precluded? Right, he doesn't rule on 12B6 grounds except for the stalking. I didn't even understand him to rule on 12B6 grounds on the noise complaint, but that's not before us anymore because Ms. Egenti has said she's not pressing noise or stalking.
Yes,
So
that's-
he didn't rule, he only ruled on preclusion grounds for the hot water and the pest infection. And you think that I mean, once he said they're precluded, she's not gonna move to file an amended complaint, is she? That would seem to be frivolous,
right, there was no.
right? So if we were to reverse and say, this isn't precluded, I don't see any reason why she couldn't file an amended complaint at that juncture if she needs to.
She would not have been, you're correct, Your Honor, she would not have been prompted to file an amended complaint.
Did you argue either in the trial court or in your brief that she had failed to plead a breach of the implied warranty of habitability?
I don't believe we did, Your Honor, because it was not raised in her complaint. I understand that Javins may say that a breach of implied warranty is part of every lease, but she did not specifically raise a count for that or a claim for that
If I tried to do some light research during the argument, and I think she's right that we generally treat breaches of the implied warranty of habitability as breach of contract claims. At least the same remedies are available for them. You will see them separately pled quite a bit, but it doesn't strike me as being strictly necessary. Or when dealing with a pro se plaintiff, would you want to be particularly exacting about what they call their claim? And the way I kind of see it, at least as to the hot water claim, it strikes me you could read her complaint and think one of two things. Well, of course, there's a lease because she's a tenant, and hot water is just invariably going to be a condition that's, some statement of habitability is probably in the lease, and absent that, it's implied. And so that's going to give rise to a breach of contract claim. Why do you think, just sticking to the hot water for a second, which seems like such a basic thing that obviously is included, that tenants have a right to have. Why isn't that enough to state a breach of contract claim?
It would be if you're calling breach of contract, which you are, same thing as breach of warranty of implied habitability, that would be enough, Your Honor.
I mean, I might agree with you on the fruit flies. I mean, I don't know what she says that the landlord is supposed to do. I mean, fruit flies seem like a pretty localized problem that tend to be unit by unit, I would think, at least, I get fruit flies in my house when I let fruit rot. I've never had them migrate from a neighbor's place, but so maybe that needs more details, but at least on the hot water, I don't understand what more she would need to say.
I just want to make sure I understood you correctly. Did you just concede that, at least as to hot water, she said enough in her complaint?
Yes, Your Honor, I believe so. But as to the fruit fly, she does not allege why that's the landlord's fault. As far as hot water, I'm not sure of any way a tenant could contribute to a lack of hot water other than damaging the system, the plumbing system. And that would be, the hot water would be more of a summary judgment issue. I do not have anything further, Your Honors.
Thank you, Mr. Moore.
Thank you.
Swanson will give you 3 minutes, I think you asked for.
Yes, thank you, Judge. So I've heard the landlord to concede that the failure to provide hot water is a violation of the lease because the implied warranty of habitability is included in it. I'd like to address the claim that the landlord has not conceded, which is the pest infestation. So pointing to Housing Code 400.3, that deals with vermin. It requires that the furnishings are in clean, safe, sanitary condition, in repair, and free from rodents or vermin. Ms. Egenti's complaint, which appears at JA 111, alleged that there was a pest infestation. I think that that is certainly sufficient.
It's definitely a defense to that it's the tenant's fault.
And-
We see that all the time. If you create the conditions for a pest infestation, you don't get to hold the landlord liable for that.
Yes, Judge, and the landlord was free to make that argument and didn't here. Instead, the landlord argues only that it was insufficient for Ms. Egenti to allege that there was a pest infestation.
Well, maybe it's that it's insufficient to allege there's a pest infestation without attributing any cause to the landlord. I mean, nothing in the complaint. I mean, I get she's a pro se litigant, so
Yes.
Maybe that's enough to get her home. But I will say, maybe I'm just being weird about fruit flies right now. But it is not obvious to me, that the landlord, what she would be alleging that the landlord has done, should have done, failed to do, that caused a fruit fly infestation in her unit. And there needs to be, something. Not my fault, at least. Seems like it needs to be in there, and she doesn't say that.
So I don't believe that this court has ever held in the context of a pest infestation that more is required in the complaint. And here the landlord certainly didn't argue in their brief that more was required. If the court disagrees that alleging a pest infestation from 2021 through November 2023 in the form complaint is insufficient, then certainly Ms. Egenti could amend that. And I think amendment rather than dismissal would be appropriate here. Going to the question of what the landlord raised in their brief, that appears at pages 6 to 7. And here the landlord said only the complaint alleges a breach of contract, but does not say what contract exists or define the parties to any such contract. The complaint does not plead Gateway had an obligation or duty related to the claims alleged, nor plead the occurrence of a subsequent breach or obligation or duty. And I think that what we said in our reply brief at page 4 is sufficient given that, and hearing the court's questions about whether or not an implied warranty of habitability breach is a breach of the lease. We provided the Javins case as well as the Winchester Management Corporation case, which appears at 361 A second 187. I'd also point the court to provision 301 of the Housing Code, which codifies that common law and says that a breach of the Housing Code is a breach of the implied warranty of habitability, which is included in every lease. I'd be happy to answer any further questions that the court has. Thank you.
Thank you very much. Thank you both for your arguments today. The case will be submitted. Third case this morning is still this morning, can't see the clock. Is number 24 CV 58 Daisy Dixon versus John Paul Mitchell Systems.
Good morning, Your Honors. Tom Wilcox here. For Ms. Dixon, I'd like to reserve 3 minutes for rebuttal. This case concerns the grounds for standing for a person suing under DC Code Section 28.305.
Can I ask you a threshold question right off the bat? Sorry
Yes,
to
sure.
interrupt your introduction, but is it your argument that tester standing under K1B does not require the satisfaction of Article 3 standing and
No, that is not my position.
okay. Do you argue, do you have an argument about Article 3 standing in your brief?
Just that the words of the amendment, the 2012 amendments that added the word test or evaluate. Okay. Those words were only intended to distinguish a public interest organization and a person from a consumer. A consumer consumes a product and simply to distinguish, to make it clear, these, that these were people who were going to be testing or evaluating. And that's very broad language, okay? Since it's test or evaluate, if all you have to do is test or evaluate to meet Article 3, then an evaluation of prior testing is sufficient. It would not make sense for the words test or evaluate to be.
But the whole point of tester standing, and I think the language of the statute is they're buying it to test or evaluate. You don't need to buy it to evaluate the research that had already been compiled about benzene. Like how did buying aid her in evaluating the product?
It didn't, but she suffered the item of the purchase. You're assuming that the purchase has to be made for testing or evaluation. The purchase is the injury, right? Because she's paid money for it.
Well,
And
the injury, if she buys something not knowing, being misled about defects.
Well, no,
Which there's no
because
allegation of that because she's familiar with the research
she
before she buys
knows,
it.
she knows it's defective when she buys it. She knows it's likely, it may well be contaminated when she buys
And
it.
I thought the whole point of tester understanding was that there didn't have to be an actual injury in this consumer sense, right? Like.
Well, there
that
has
was
to be,
why-
there has to be, the failure to provide truthful information is the injury. And,
Right, but you just were saying that the purchase,
well, there
was
is,
the
there
injury,
is a
but that
bright line that she can't just
clearly
walk
not
down the
correct.
aisle. She can't just walk down the aisle and look at a product and then sue. She has to actually purchase the product. But that's the test or evaluate, okay? Simply because evaluation doesn't require a purchase doesn't mean evaluation can't be sufficient. An evaluation can't be sufficient. Otherwise, why would you put in the word evaluate? If you can test or evaluate, then evaluation and evaluation alone, based on prior
excuse
testing.
me, it seems like evaluate could be for a whole lot of reasons, right? Because I mean, testing has one connotation of your maybe, analyzing the chemical substance, but evaluate is like, you're looking it over to see if it has all the features that are promised, or, you're actually using it to see how well it works, or, I mean, evaluate could be broader than testing.
And that was the whole point that's my whole point is because evaluate is broad, that is consistent with the fact that these amendments simply codified the broad scope of the broad scope of Grayson. Grayson didn't test anything. Grayson was an industry insider who knew that the product in question was defective in his view because
He wasn't, they weren't claiming
test.
tester standing though,
What's
right?
that?
They weren't claiming tester standing.
He
Grayson,
didn't do any testing.
right.
Right.
It wasn't
Okay,
claiming
so-
tester standing. It was just
What's
claiming, he was claiming standard Article 3. I bought a thing that was represented to have all these properties. It didn't actually have all those properties. I've been
No,
injured.
Grayson precedes tester standing in the statute.
Well, he knew he was able to evaluate based on his
It
knowledge
didn't
of
have
the
anything to
product.
do with test or evaluate at all as far as the statutory language is concerned, because Grayson preceded the statute, including tester standing.
Right, but
Am I wrong about that?
But
Grayson is one
test,
reason why
evaluate,
we added tester standing to the statute.
I'm sorry, Grayson,
Grayson, I think, is one reason that the council contemplated adding tester standing to the statute. So Grayson has nothing to do with tester standing.
okay, but the statute now as written says test or evaluate, so why wouldn't, I don't understand how it is that an evaluation of a prior testing is not sufficient. It was sufficient in Mustafi. And
Yeah, the reason why it's not sufficient is because the point of tester standing is I might not be misled, right? If I'm a consumer and I know, I think there is something wrong with this product. So the actual labeling and the representations about the product aren't misleading me. So I can't quite say that I have standing because I haven't been injured by the misrepresentations. Because all along I've suspected this thing is defective in some way. And I buy it to test and see whether or not it is in fact defective. Whereas here, if you're talking about evaluating prior research done on benzene in this dry shampoo, purchasing it serves no function at all. It doesn't aid in the testing or evaluation. It's just sort of like a total non sequitur, for lack of another word. Like the buying is totally irrelevant.
the buying, but it still must be bought to have standing because the injury is the money paid. and you have failed to receive truthful information about money paid. Any contrary interpretation requiring, in this particular case, this particular case where, say, 10% of the product is defective, you would vitiate subsection K1B, because how, if only 10% of the product is defective, could a consumer possibly find a defective product? You have to keep on buying and buying and buying and testing and testing and testing until you found one. And there are many cases like this. There are many contamination cases. There are many cases where only a small percentage of the products are in fact defective. And if you said that we're saying the product is contaminated, 10% are contaminated, but all are defective because the reasonable consumer would not purchase it if it had the fact that it had carcinogen, toxic levels of carcinogen in it.
But then she did.
What's that?
But then your client did. She knew all of that and she bought it anyway.
Right, but she is the person, and she can know beforehand. She's in touch, just as Grayson did.
I don't remember.
The amendments didn't change.
I don't know if Grayson got into sort of why that was an injury, if he knew all the details.
No, it did get into exactly what his injury.
Sure, but it wasn't a tester standing case. And you haven't come before us saying, I've checked the boxes of injury, cause, and redressability under Article 3. Tester standing is sort of a little carve out to that, saying, well, you don't need real injury if what you're doing is providing sort of a social utility of ferreting out bad actors. I think that kind of stems from Havens Realty, where you've got somebody who's out trying to ferret out racism in landlord rental decisions. Even if they weren't interested in actually renting the property, which they weren't, the Supreme Court said, well, you have tester standing, you're providing a socially valuable function by going out and ferreting out this bad stuff. Your client is not providing any useful function by buying a thing she knows is defective and then coming to court to sue. So why would we relieve her of the standard Article 3 injury, cause, redressability requirements?
But what she's supposed to replace, because of the lack of funding I'm not sure what you say by socially valuable. The idea of the section K1B for a person to go out and buy a product is to get an injunction to stop the product. It's prophylactic in nature. You get an injunction and you stop the sale of the product. That's the social legal function, is filing a lawsuit. That was the whole point. The whole point of Grayson and Grayson, not the city. The amendments don't set the limit of standing in the Court of Appeals, and the facts in Grayson really determine what is appropriate standing under Article 3. And there was a purchase of a product that he knew to be defective. He knew it was defective when he bought it. Mustafi, he suspected based on prior testing. Mustafi was the same thing, exact same facts. And Judge Holman said the prior UC Davis testing is sufficient to confer standing. But if you require if you take the view that the city council inserted test or evaluate in the restrictive manner, which is ironic because the whole point of the city council amendments wasn't really to expand the law past Grayson, but to codify Grayson and make it clear that public interest organizations shouldn't be hit with manufacturing standing claims, which I note is just what's happening here. Is you're claiming manufactured standing, and the whole point was public interest organizations and individuals to a lesser extent should not be hit with manufactured standing.
Can I interrupt? I'm confused, and I just want to forgive the possibly ignorant question, but what do you see as the difference between the testing standing that is required for your client in this case and the Article 3 standing? And in particular, what is your response to your opponent's argument about footnote 5 of the Animal Legal Defense Fund case.
I'm sorry,
Footnote 5 of the Animal Legal Defense
Hormel?
Fund case. Yes, or is that what it is? Yeah, Hormel, right. You know, what it says about the basically identical provision of to K1B, you know, saying it must still, unlike, you know, the provision at issue in Hormel, these other two, including, or this other provision, which is identical to ours here, must still meet the traditional Article 3 requirements. What, can you just clarify for me what you think the Article 3 requirements that you are required to meet in this case are, and how they
That's-
differ from the testing? Or are you still, or are you thinking of it, the way you're talking about it makes me think you think it's basically replaced by the testing? And I might just not be understanding what you're saying, but if you could tell me what you think the Article 3 requirements are for your client.
Well, as articulated in Grayson, that they purchase a defective product. Okay, and this product is defective because the general public wouldn't purchase it if they knew that it might be contaminated. You know, and so just like the Attorney General, there's supposed to be the same level of standing. You don't have anyone who's been specifically physically injured, but you're aware that a percentage is out there. So you can go forward prophylactically and stop the sale. So it's either a testing or an evaluation of prior testing. But I mean, there was testing here. Exactly, and I mean, is my client gonna do testing? No,
I'm
she's
still
not gonna do testing.
I'm
It
still
would
not
have to be,
understanding the answer to Judge Beckwith's question.
sorry?
I'm still not understanding the answer to Judge Beckwith's question. Do you think that your client has to satisfy Article 3 standing requirements and the testing standard, the tester standard under the statute? Or do you think the tester standard supplants Article 3 standing?
I think that they have to saddle both Article 3 and the test or evaluate, but test or evaluate was
Okay.
meant to be
So what do
broadly.
you understand? What are the Article 3 requirements and how are they satisfied here?
They have to suffer they have to suffer an injury in fact, which is the purchase of a product, the purchase of a defective product. That satisfies Article 3 standing under Grayson.
And it's defective. Why? Because, I mean,
It is defective because it might be contaminated and therefore a member of the DC general public, not the person who buys it, not Ms. Dixon.
I mean, in Grayson, right, it's like phone cards or something,
Right.
right?
So every one of them was
Every
defective.
single one of them is defective. right?
What
There's
about-
no- There's no issue about that. I'm trying to understand like why the possibility of contamination means the product that she purchased is defective.
Because it, like all the others, is something not her, but the general public would not purchase. She bought a product that the general public would not purchase if they were aware that it might contain benzene in toxic levels.
Where are you getting that standard from? The
I
general
mean,
public wouldn't buy it.
well, there's some federal case law that is consistent with that.
And is the point just that the risk of contamination is sufficient and you have case law that
No,
supports?
Henning was Henning is a California case saying the court found plaintiff plausibly alleged the risk of benzene and she would have not have purchased the product had she known about the risk. This is sufficient to plead standing based on economic injury. Okay, that's standard Article 3 standing. If you take the position in Nelson and say, well, they had to purchase a defective product, Nelson also denied injunctive relief. Well, if injunctive relief is dependent on buying a defective product, that's clearly not consistent with clearly not consistent with Grayson or article, or this is FRCP 23 has a higher requirement. They have to rely on the product in order, on the misrepresentations. And Ms. Dixon doesn't have to rely on the representation. So the Rule 23, the Rule 23 standing is articulated by Nelson, not only denies standing, says, well, you have to have known about it, but also, well, because you knew about it, you can't have adjunctive relief. Well, Ms. Dixon knew about it, so had she done, I mean, even if she had done testing, she wouldn't be entitled to adjunctive relief because she knew about it beforehand. So the Nelson case shows the difficulty, shows the problem with applying, traditional Article 3 standing. And the difference with the person in K1B and the public interest organization is they don't have to rely on the representations. They can know it's false when they buy it, and then set forth an evaluation of why it's false to the court.
Or they don't
But
have to know, they might suspect.
What's
right?
that?
They might suspect.
They might suspect, or they
right?
might know.
And
Grayson knew.
so they're not misled, right? I have a family member who's using some product
Right.
that says like, anti-aging cream, and I think, well, that's not true. And I buy it and I test it and I determine that it doesn't have the properties that is advertised to have. That seems to be
Right,
that's the heartland of the tester standing.
right. So but since
But here you're saying, okay, she has reason to suspect that, that this is a defective product. I mean, she doesn't know that she's buying the defective product because all she has is a test from a different batch saying a different batch has benzene in it. And so she buys her, she makes her purchase and she doesn't test it.
she evaluates it.
Well,
As
how
per
does she
statute.
evaluate? I mean, she doesn't do any more evaluation other than looking at a test for a different batch.
But that's
from
considerable evaluation. I mean, that's reviewing all of.
Is it sufficient evaluation to get you to tester standing? That's what I'm not quite understanding. Why should that be enough?
Well, I mean,
if there is if a prior study says that there is, 0.001% chance that there is benzene in this product, right? From a batch from 5 years ago. And then she buys the product and says, well, I evaluated it under this study. And so I think that, I should be able to sue. Would you think that she has sufficient standing to sue on that basis?
no, because that evaluation, the court look at it on a motion to dismiss and say, look, this is just too far small. This is just too insignificant. You've got something 5 years ago. Okay. And that percentage of risk is in any product, right? I mean, it falls below the standard of any product possibly being defective. Here you had 10%. Okay, but I don't understand. What I see is
I mean, why is that enough? There's 90% chance that, or even in a 10% in the batch that was tested from, I don't know how many years ago. Like, why is 10% good enough from a different study of a different batch?
that would be part of the evaluation, and that's part of what the court would ask in the motion to dismiss is where is there a sufficient line? But if you,
Question.
what's that?
Why isn't it a standing question?
It might be, but it wouldn't require testing.
I mean, do you think that as long as there's any evaluation of any sort, then that gets back to my.
Does it satisfy Rule 11?
0%.
Does it satisfy Rule 11? Testing is what you produce in 26 before
Like
report.
making false representations to a court rule? Is that what you're talking about?
Well, if you have such a poor argument that it just, you don't have to make false.
Go that way, right?
lacking
People file frivolous complaints all the time and don't run afoul of Rule 11 sanctions.
Well, I thought for Rule 11 would be a frivolous complaint. I mean, my point is that if you say she must test, what was the purpose of the board evaluation in the statute? Why did they say test or evaluate for both individuals and public interest organizations,
Her to
particularly
do
when they're,
something with the product that she purchased.
okay, so okay.
And she.
No, it didn't say she had to, it doesn't say she has to evaluate, it just says she has to buy it for the purposes of testing or evaluation. It doesn't say she has to test or evaluate that specific
just goes
product.
back
You
to
would
Judge-
vitiate,
Judge Steele's question of what's the point of buying it then?
what's
Like,
that?
What's the point of buying it then?
Well, you limit people from simply walking down the aisle and looking at product after product after product. And simply saying, I'm bringing a lawsuit based on just walking down the aisle and looking at them. The point of the purchase, part of the purchase is so that there is some financial injury.
So
Right?
that is,
And
the
that-
purchase
I mean-
is dealing with your Article 3 standing issue.
Right. Right. So you've got the purchase is what satisfies Article 3. And, even with post-Spokio, it makes it a bit clear. You have to have some sort of financial injury, and you also, but it is not traditional Article 3 standing in that you don't have to rely, as in the class actions, on the misrepresentation or not know that it might have benzene. You just have to buy it because or you suspect, as Grayson did, or suspect, as in other cases, that it's defective. And, I mean, any alternative reading would render evaluation meaningless. Because if you had to test, what's the purpose of the board evaluation? I mean.
There are things that you can do with products that you would call evaluating without.
sorry?
There are things you can do with products that you would call evaluating that you wouldn't call testing. Like if I buy a basketball, and I take it home and it can't inflate and I can't dribble it, I don't think I would say I've tested it. I try pumping it up, I try bouncing it, it doesn't bounce. I've evaluated it, I say this basketball doesn't bounce. So I think it is something like, kind of like a synonym, don't read too much into the word testing like it requires some expert. Sometimes people can evaluate things and know that they're faulty just by kind of looking and touching them and trying to bounce
Right.
them.
And here's the problem. You buy the basketball, one doesn't bounce. How do you know whether that's a systematic problem or not? You have to do further evaluation to see, have there been other complaints? What was, and really with that, the defendants would come back to you and say.
Yeah, but my point is your client didn't bounce the ball. She didn't bounce the
She
first ball.
researched. She did the research.
Yeah.
We did the
The
research.
buying it was pointless.
What's that?
The buying of the,
No, the
buying it was
buying-
totally
the
unnecessary
buying-
to the evaluation.
The buying creates it doesn't matter. They're two separate things. One is the purchase and the other is the evaluation.
I agree they're separate things.
Okay, I'll take 3 minutes for rebuttal.
Okay, thank you.
Good morning, Your Honors. My name is Peter Nanoff. I represent the appellee John Paul Mitchell Systems. May it please the court. Despite the various assignments of error in appellant Ms. Dixon's brief, there's only one issue in this case. And that is to have testers standing under the DC Consumer Protection Procedures Act. Does the plaintiff have to actually test the specific product at issue to be able to allege facts that demonstrate a violation of the CPPA? This court should answer that question with a resounding yes.
I hate to keep beating this drum, but just to interrupt. Weren't you arguing that the plaintiff did not satisfy Article 3 standing requirements? And how do you read Judge McKenna's analysis of the CPPA claims? Do you think that she is addressing Article 3 in that analysis?
Your Honor, I don't believe that Judge McKenna got that far. I think under either constitutional Article 3 standing, under prudential standing, this pleading is insufficient under both. Because Article 3 standing requires an injury or immediate threat thereof. It requires demonstration or, allegation of a case or controversy. Prudential standing requires that a claim fall within the zone of interest that is to be protected by the statute. Here, we have neither. We do not have a allegation of an injury. The argument that the purchase of the product was the injury doesn't apply in this case. That argument only applies in cases where the purchase was made without knowledge of the potential defect.
I guess where I'm getting confused, but maybe I just didn't hear you correctly, is it seems like the CPPA is currently drafted to allow tester standing. And in those scenarios, that person doing the testing would not have an actual injury. I mean, beyond the purchase, but they might have purchased the product, not being misled by it, not thinking that it does what it does solely to test it. So are you, how does the Article 3 standing and tester standing under the statute, how do those two things interact?
Your Honor, one of the traditional factors of standing is a actual injury or an imminent threat of injury. The tester standing amendments of the CPPA, I believe, tweak what the court is intended to understand that immediacy of the threat of injury to be. So when you have
So if you can show, I mean, just to cut to the chase, if you can show that you have tester standing under the statute, you think then you also have Article 3 standing? Is that fair? Or is it not that simple?
Yes, Your Honor, I believe that is the case. If you have purchased a product, tested the product, and that test demonstrates that the product at issue, it contains some sort of violation or reflects some type of misrepresentation under the CPPA, then yes, you would have Article 3 testing.
So you think that we're just confronted with a straight up statutory interpretation question?
Yes, Your Honor.
Okay.
Yes.
And I mean, do you agree that the statute, it's not written maybe as well as it could have been? I mean, it doesn't say you actually have to test, right?
The statute does not specifically phrase it out in that particular language. However, the phrasing of the statute with respect to the concept of a product being purchased for the purpose of testing or evaluation is solely to distinguish the purpose of that purchase from a consumer purchase under the Act, which would be made for personal or household or family use. Purchasing a product to test it is not purchasing a product for personal, family, or household use.
Okay. And so, I mean, your appellant's argument is, okay, but she purchased it to evaluate it, and she evaluated it sufficiently by looking at tests of a prior batch of shampoo from some earlier time.
Yeah,
And
that's,
you think that fails because that's not evaluation?
yes, Your Honor, that is not evaluation. In fact, it's nothing. It's just purchasing a product based on some other
So
entity's
you think
test.
the evaluation of the product has to be of the product that was purchased?
Yes, Your Honor, because under the statute, that's the only thing that can create
Well,
a
what if-
factual.
But what if, I'm sorry to cut you off, but just to quickly move this along. What if I buy a product and a week before a study comes out saying that there's a 95% rate of contamination in the facility that manufactures the shampoo, right? And I can show that this shampoo was manufactured in that facility. Would that be enough? Would I have to do more evaluation than that?
Yes, Your Honor, because in that scenario, there's still no factual demonstration that a product that was purchased or received within the District of Columbia, which is what is required to trigger which is one of the factors required to trigger tester standing under the statute, is actually contaminated. To trigger the statute, you need two things: purchase or receipt, or to trigger the statute and tester standing, you need two things. Number one, purchase and receipt of the product within the District of Columbia, such that the statute applies in the first place and that this court would have jurisdiction
Let's
over it.
put that aside. I felt like that wasn't so much where the argument was before. I mean, let's assume that that's satisfied. And you just have my hypothetical of a recent test from the facility where this product was manufactured, showing a 95% rate of contamination by toxic chemicals. And I purchased the product and I cite that test. Is that not, that's not enough?
No, Your Honor, and
I
again,
have to like go out and pay to duplicate those results?
yes, under the statute, what is required is that the specific plaintiff who is engaged in this test, whether it be an individual or a nonprofit organization, must conduct or commission some type of test or evaluation on the specific product that reached the District of Columbia. That is,
Yeah, I
Without
still
that-
feel like that reached that, like, assume it reached the District
Okay.
of Columbia, but this product definitely was manufactured in the facility that recently had a study that said it was 95% likely to be contaminated.
yes, Your Honor, because the whole concept of the CPPA is that a misrepresentation must have been made that is inconsistent. The only way to plead facts to suggest that this particular purchased product is affected by this misrepresentation is to test that specific product. Otherwise, you are just guessing or surmising.
Are you evaluating it by looking at it and reading the label and knowing that it is the same product that was, you know, produced in the circumstances that Judge Easterly described?
No, because well, if you go back to the Praxis case, Your Honor, that was exactly what was alleged in the Praxis case, is that there was a test or an evaluation that consisted only of reading the label. But in that case, the court said that the test did not match the allegations. In that case, the allegations concerned whether a calorie of Coke constituted the same calorie of, or was the same as a calorie of any other food. And the testing that was
It just seems like a
conducted,
different issue. I mean, change my hypothetical and the tests that has been done shows that there is 100% of contamination by toxic chemicals in the facility where this product was manufactured that I purchased in the District of Columbia. And I can't, if I plead that and say, I bought it, and here's the test, that's not enough for me to show standing.
correct, Your Honor. And again, it's because the foundation of the statute is that it is basically tweaking the immediacy of the threat of injury. And instead of requiring an actual injury, it is saying that we are going to allow someone to come along and test the specific product rather than being injured by the specific product. So if the test is known, or if test by some third party at some place at some time is known, then
That's for the Attorney General to bring, or, I mean, it's just, that can't be done by an individual.
well, it certainly could be done by an individual. An individual could commission the test, and depending on the nature of the allegations, an individual could conduct any type of different test, depending on the nature of misrepresentation.
Presumably, the Attorney General wouldn't have to do its own testing. It could just sue and say, there's a test saying that this product is 100% likelihood of having toxic chemicals in it. You can't sell this in the district anymore.
Presumably,
Under the
Your Honor, although
CPPA.
admittedly, we are not arguing this from the perspective of a Attorney General action. This is,
I'm just trying to figure out from standing purposes, like to the extent that there's a concern of like, oh, what do we do if this individual doesn't have standing? It seems like the CPPA offers other people as actors who can sue on behalf of consumers, right?
It does, but Your Honor, the problem with the hypothetical that you present is that it establishes or allows for a sliding scale of consideration where standing should contain clear lines for this court to be, and for the Superior Court to be able to enforce.
And so the clear line as you see it is that the person claiming tester standing always has to do individual testing or evaluation of the product that they purchased. That's how you want the court to interpret the statute.
Yes, Your Honor, because otherwise you are presented with these sliding scales where under your scenario, there is 100% purchase, 100% contamination.
But you don't necessarily require the individual to do the testing personally,
No,
right?
Your
Like
Honor.
I could get the anti-aging cream and send it out to a lab to get that product tested.
Absolutely.
Okay.
But you as the
But
tester,
it is the product that I purchased that has to be tested
yes, Your Honor.
or evaluated.
Yes.
I mean, put aside tester standing for a second. What's wrong with his argument that, there's just straight up Article 3 standing that, purchased a product. It was defective in a way, and the CPPA doesn't require actual reliance on the misrepresentation. And so forget about how they've litigated it as tester standing. What about just a straight up, a more standard Article 3 standing? What's wrong with that?
I'm not sure I understand, Your Honor.
I was injured because I paid money, and I think your answer is, but you weren't affected by the misrepresentation because you understood the defect before you bought it. I think that's your argument to a straightforward Article 3.
Yes, Your Honor.
And I thought the CPPA, and maybe I'm misremembering, had made it explicit that actual reliance on the misrepresentation isn't required, but maybe that's only for public interest organizations and consumer rights organizations. I can't recall.
Your Honor, yes, for purpose to address your question, the first part of it is an actual injury only arises with the purchase of a product if you were not aware of the potential contamination. If you are aware of it and you purchase the product knowingly, then you do not have an Article 3.
Yeah,
injury.
so one thing opposing counsel says is, well, that's inconsistent with Grayson. Because Grayson, you have, the head of a telecom, I think it was a former president of the telecommunications firm, and bringing the suit. Something about breakage, leftover minutes on cards weren't being refunded. And he knew about all of that, bought the cards and brought his suit. I'm not sure how clear that is from Grayson, but what is your response to that view that reliance is required is inconsistent with Grayson?
Well, Your Honor, as the court pointed out, Grayson was decided before tester standing came along. The whole idea of.
Yeah, I'm trying to get rid of testers. Forget about tester standing.
Sure.
This whole line of questioning is, I think it's weird that they're trying to put this in tester standing world. And I don't think it works. But I'm curious just about more ordinary, and maybe there's not a good statutory hook for just sort of, I bought it. There were representations about it that were false. And so forget about testing. I just check the injury cause redressability boxes, and I hear your answers being, well, there was no reliance because she understood about the defect, and his answer to that is Grayson. There's no reliance there, and we said standing under the CPPA nonetheless. So what's your reaction to that?
Your Honor, tester standing was written into the statute to allow for a situation where reliance is not required. Before tester standing was implemented into the statute, reliance on that misrepresentation was required.
So he misreads Grayson, is that your answer? I mean, I'll go back and reread Grayson. I probably haven't read it carefully enough, but he's telling me, maybe this is right. They've got somebody who's not relying on the representations to buy the calling cards because he already knows that the breakage isn't being refunded to the district or something like that. That's an incorrect reading of Grayson is your answer? Grayson did something wrong and unthoughtful? Is that your answer?
Your Honor, my understanding of Grayson is that there was an allegation that a calling card was purchased, that there were funds that were not escheated to the state as was required, and there was no allegation regarding the argument or the allegation was that by failing to escheat those funds to the state, that was the violation that had occurred. I don't believe there, and I could be wrong on this, but my understanding was that Grayson did not turn on reliance on a misrepresentation. It wasn't an issue that was before the court because it wasn't disputed. The question was whether the individual had demonstrated standing through the purchase of the product in the first place. I see that I'm out of time. I would like to close, however, by addressing one of the arguments made by Ms. Dixon in her reply brief. And that was echoed again today. The argument that somehow the Superior Court's ruling in this matter eviscerates the CPPA, or that the interpretation that we are asking this court to reach would vitiate the CPPA. First, that argument was made by Ms. Dixon as admittedly for the first time in her reply brief. Therefore, this court should not consider it at all. Second, Ms. Dixon has argued that the Superior Court's interpretation actually violates the CPPA itself. She has not explained how it does so. Third, Ms. Dixon has argued that it is simply too much to ask a prospective representative action plaintiff to either A, find contaminated bottles of product on which to base their lawsuit, or B, which Ms. Dixon completely ignores, purchase and test the subject products at issue. Ms. Dixon seems to misunderstand the concept of a representative action. The law was not written to allow plaintiffs, or more accurately, plaintiffs' lawyers, to be able to make an easy claim and make a quick buck. It was written to allow individuals to be proactive in testing products, to be able to sue on the basis of those tests, rather than requiring them to be injured by a product. It is not sufficient to just read an article about someone else, about a test conducted by someone else at some other time, buy a product of that variety, and file suit. Ms. Dixon's argument seems to be that this court should adopt standing on the basis of a guess or a mere possibility that a product is contaminated. Standing simply requires more. It requires an actual case of controversy. Historically, that was achieved through an actual injury. Here it is achieved through tester standing and that tester standing is based on the testing of the specific product at issue. Tester standing is not a misnomer. The testing has to be done, and it must be done by the specific litigant. Ms. Dixon therefore has failed to demonstrate standing to bring her claim, and appellee John Paul Mitchell Systems respectfully request that this court affirm the decision of the Superior Court. Thank you.
Thank you. Mr. Wilcox, we'll give you 3 minutes.
Yeah, take 3 minutes. I just want to follow up on. I do think that under Grayson, yes, it would be sufficient. He clearly was an insider who knew about this before he left the company, and then brought the suit afterwards based on basically no evaluation or any testing, just his prior knowledge. It takes a careful reading of Grayson to determine that, but it is there. Also, I want to follow up on your basketball. A consumer, a person who's really going to be a consumer, can't really test or evaluate in that. They're not sophisticated. They don't really know what proper testing is. They don't really know how to evaluate. I mean, the praxis evaluation, which did not rely on any prior testing, was just, we looked at it, we did a little math about the amount of sugar in it. If you took your basketball case, the person said, well, I dropped the ball and it didn't seem to bounce as much as I wanted it to. The response of the defense would be, well, wait a minute now. You've got to test it. You've got to, make sure the floor is right and do it under controlled circumstances. In other words, you've got to do testing. So you can't, once a consumer starts to evaluate, particularly a consumer who suspects it's defective, you have to, their response is simple, no, evaluation can't be, in no circumstances is evaluation good enough. You gotta do testing, which again is in direct conflict with the statute, which permits testing or evaluation. And I mean, I think the argument was at least implicitly raised in the appellate, in our opening brief, and then we're saying it's an unduly restrictive interpretation of the statute. And would eliminate so many cases where you have intermittent defective products. So yeah, I think it satisfies the requirement, the reading and evaluation really by lawyers. I know his complaint is the lawyers. The statute is the way it's written. It begs for lawyers to go out and do the work, because a person without any legal training is just not going to have the sophistication to do it, testing or evaluation, either of which alone is acceptable. Thank you.
Thank you. Thank you both for your briefing and your arguments today. We will take the case under advisement and we are adjourned.
All right.